Great. So again, welcome again to the Disability Rights Consortium meeting, New Developments in Special Education Law. We're really thrilled to have Professor Mark Weber from the DePaul College of Law with us. For those of you who are frequent attendees of the consortium meetings, you'll remember that Professor Weber has been very generous with his time and have been an annual speaker, usually around this time of year, providing us with a wealth of information. And this year, he's going to be sharing with us new developments in special education law, as well as some recent ADA Section 504 cases at the end that are, I think, on a lot of people's mind, raising some very important issues. Folks, I'm sure know that that Mark is just, world famous in his expertise on disability law. He wrote a great book on disability harassment that I would highly recommend if you haven't read that, and also has written case books on special education law. So we really have one of the leaders in the field with us today and are so fortunate to have him here. So I'm going to stop talking and turn it over to Mark and let him get going with the new developments in special ed law.
Thanks a lot, Barry. Thanks a lot for the introduction. That's great. I really appreciate it. I should maybe add a word just about my background. I've been doing special ed law in one way or another since about the early 80s, and my perspective very much began as an advocate representing families and children. And I think I've hung on to that perspective to some degree, although I've tried to be as impartial as I could in an academic sense or in doing academic type writing in more recent years. But I should probably mention that the perspective I'll be taking throughout the talk really is going to be emphasizing advocacy for families and for children, rather than trying to create some sort of objective view of everything that we'll be talking about. So what will we be talking about? Well, as Barry said, we'll send out the slides after the presentation, but I do want to make sure that folks are able to follow what's going on here. The idea is to try to cover, at least with a word or two, pretty much every one of the published courts of appeals opinions for the last year that interpret IDEA. I probably won't be able to cover absolutely everything, but I'll try my best on that. In addition, I want to make sure that I cover Illinois developments over the last year, some of the Office of Special Education Programs interpretations, and a few district court opinions from out of area that I think might be of significance. I will not be addressing Illinois legislative developments because that's kind of more than I thought I could sandwich into the presentation, but there have been some important developments this year, and there are other sources by which you can get a hold of them, but I certainly want to make sure that you're aware that things have been happening on that. Then at the end, as I mentioned, or I guess as I didn't mention, as Barry mentioned, we'd like to maybe spend a little bit of time talking about the Cummings case out of the Supreme Court and about some Section 504 related developments in general. So I'll try to reserve some time for that, in addition to reserving some time for general questions and answers. So where are we? Well, I'd hope to kind of follow through the development of a kid through special ed kind of linearly. So starting with child find, onto IEP, onto what constitutes appropriate education, and then gradually segue into what you might describe as the more remedial or procedural issues having to do with special ed law. So what we begin with is the child find, evaluation, and eligibility type stuff. The first couple of cases are maybe not all that remarkable, except for the fact that they do come out of courts of appeals. So what about them? Crofts is one that involves a kid who was initially both evaluated for and deemed eligible under specific learning disabilities. Parents said there's evidence that this kid has dyslexia. He ought to have been given a specific dyslexia evaluation and ought to have been given more specific dyslexia services. Court of Appeals, long story short, says no, that the specific learning disabilities evaluation was adequate and the specific learning disability services were adequate. There might be a subtext here, and it's a little hard to tell. Some states and some localities have special kind of enhanced programs for dyslexia, and it could be the parents were pushing in that direction, but it doesn't come out from the Court of Appeals opinion. So it's a little hard to tell if that's really what was going on. But otherwise, basically, parents lose is the bottom line of the case. Similarly, the next case, this Leanne against Riesel or Reisel Independent School District case out of the Fifth Circuit, this is one that's a little less directly connected to evaluation and a little more directly connected to child find. The kid had a real mixed record, was obviously struggling, had a bunch of disciplinary stuff, wasn't determined to be eligible even for evaluation until about ninth grade, when the parents finally requested it. And the court said, well, yeah, but the kid, after all, did get some interventions. The school district, once the evaluation request was made, did evaluate the kid within about 8 weeks. And what's more, and this I think was actually the thing that was probably the most important to the court, the parents had actually gotten an evaluation 7 years earlier, indicating greater disabilities on the part of the kid, but never shared it with the school district. And although, again, you have to read between the lines a little bit, it could be that that's what was going on in the case. Bottom line there, it does appear that parents may be penalized if they don't provide all of the information to the school district that they have when they have it. Although I think probably all of us know of situations where parents are reluctant to share information of that type for fear of a kid being labeled or for the kid being kind of shunted into a low expectations program. So I'm not sure that the Court of Appeals realized that that might be a concern. So those are a couple of more or less garden variety cases in my view. The JN case, which is the third on the list here, is I think more significant. And this is one that I would really make note of. Big thing about this one is that the kid struggled for a fairly protracted time. The Court of Appeals was willing to recognize that the kid should have been given a full evaluation and should have been deemed eligible a lot earlier than what ultimately happened. It wasn't until actually 8th grade that the services started to begin. But, and here's the kind of big interruption with respect to that, the court also said, yeah, the delay occurred, but the kid was getting various kind of RTI, that's response to intervention, or similar type things that are not special education, but are somewhat assistive and somewhat accommodating services during a protracted period of time. And you, the parents, failed to show that the delay actually worked to harm for the kid. So it was kind of a no harm, no foul kind of situation that the Court of Appeal wound up emphasizing. And I think that that's fairly significant. It seems fairly often that parent advocates don't emphasize the deprivation that the kid experienced by failing to be evaluated earlier. And that, of course, is going to be more of a challenge if at least some services have been provided. Now, are there solutions to that if the parents don't have the evidence readily available? One thing that you should probably be aware of, and this is emphasized in a case called Butler out of the DC Circuit, courts of appeals are willing to emphasize that hearing officers have the ability to order evaluations, and evaluations could go to things such as what deficiency were caused by the failure to provide services earlier, even if the parents had not previously obtained that kind of information. So I would emphasize and keep in mind as a particular lesson out of this case, that if you're going to be emphasizing child find or delays, that it really does become incumbent on the advocate to make sure that some deficiency is shown there, or there is some peril that there may not be a remedy that will do the kid any particular good. What's next? Well, I did want to make sure that we said a word or two, as he coughs, about COVID-19. Some of this is not really remarkable, but probably you ought to be aware of it. The Road to School roadmap is actually not as significant with regard to COVID-19, I think, as the fact that it says, and this is a direct quote here, can an LEA, that is a school district, excuse me, require that all students participate in general education multi-tiered systems of support or other general interventions prior to referring a child for special education. Now, this MTSS is also something that's essentially the same thing as RTI, or response to intervention. And the answer is no, flat out no. And they describe what MTSS is and say many school districts have worked successfully with that, but IDA doesn't require it, and you can't require it as a condition. So keep that in mind. The other thing, the long COVID one, this is worth noting. I mean, it seems there's so much more evidence these days of long COVID, particularly in us old folks and in young kids. And the OSERS people, the special education people at the federal level, emphasized that the other health impaired category can easily embrace kids who've got that kind of condition. We're kind of moving rapidly along, and I do want to make sure that we give full attention to every case that does merit it. The Capistano case in some ways is garden variety, and in other ways, in one particular way, really is not. So the garden variety part of it, and this is partly an unreported opinion that was issued at the same time, same date. The school district conceded that the kid had not gotten a free appropriate public ed for first grade, but both the hearing officer and the district court allowed a second year of tuition for a private placement for second grade. And the Court of Appeals knocked that out, saying that the remedy should only go to the actual shown deprivation, which was the first grade year. And in fact, the Court of Appeals also had some comments suggesting that they didn't think that maybe there really was a violation of free appropriate public education even that year, but that seemed to fall by the wayside. So short lesson from that is, if you're trying to claim for tuition reimbursement, be sure that you show a deprivation of free appropriate public ed for the relevant time period if you want to make sure to get that kind of a remedy, or else try to show that it really is a remedial remedy for the deficiency during the time that the FAP violation occurred. The other thing though, and this is the thing that I was trying to generate some suspense about, most courts seem to agree that if a kid has been placed unilaterally by the parents as part of a special ed dispute with the school district does have a continuing obligation each year to make sure that there is an IEP in place that will offer free appropriate public ed. It appears now to be the view of the Ninth Circuit that that's not right. Instead, they say that students placed by parents don't have a continuing entitlement to an IEP unless they ask for one. Whether other courts will adopt that, I haven't any idea. But again, if you're exercising caution and you've got a situation of representing parents who've placed their kids in a private placement or kid in a private placement, you should have them ask for the IEP to make sure that at the minimum that they've made sure that the school district's efforts are recorded and that you don't have any problem with ongoing obligations and failure to make sure that you've asked for the continuation of free appropriate public ed. So that's what I want to do with all of those cases. By now, you're probably thinking parents can't possibly win anything. And if people are streaming for the exits, you know, I could maybe understand why that may be so. So I thought that I would, at the minimum, throw in a few district court cases where the parents do in fact prevail. Albuquerque against Armstrong. This is one where there was a reading program, the SPIRE program, S-P-I-R-E. Problem was it was never implemented with any fidelity or regularity. Parents win. The prospective relief of various kinds was awarded. Rogich is a case actually involving a kid with a lot of developmental type disabilities. I guess the code word would be the kid is severely involved or something like that. In this one, the parents again prevail. The thing that seemed to be of emphasis to the court or of importance to the court is that the school district had been provided a bunch of private evaluations by the parent and didn't seem to consider them in any serious way. Plus, again, the programs that the school district did implement were not implemented with fidelity. It appeared that although the school district said it was offering Orton Gillingham reading instruction, none of the school personnel who testified at the hearing seemed to be familiar with the program. And I think folks have seen that in some situations that people have come to me about, where the school district does often buy a quite expensive program of one sort or another, but then because of personnel changes or falling through the cracks, don't actually get the personnel and get the other resources together to implement it. So this is a good example of where that happens. SS against Bellflower, in some ways it's a little atypical. In other ways, it's, I don't know, I guess the word would be illustrative or demonstrative or something, because it shows the importance of trying to build up a little bit of a narrative if you're trying to persuade a decision maker that free appropriate public ed has been denied. And basic idea here is there's a blind teenage kid. The kid has been served for a long period of time by the school district by a teacher of the visually impaired. Teacher of the visually impaired retires. School district says, we're fishing around for somebody, we can't find anybody, there's a shortage of personnel. What they do is they get a series of substitutes who are qualified at least to do special ed, and then have an itinerant, an aide, who's supposed to be assisting. The problem is that the special ed teacher doesn't have a clue about what it is ought to be offered to the kid. And in fact, the parent was visiting when the itinerant here was brailing some materials, and the substitute teacher said to the itinerant, so what should I be doing now? And of course, the itinerant says, I don't know what you should be doing now. You're supposed to know what you're doing now. And ultimately, the parent who'd been observing leaves the room in tears because it appears that nothing is going on for the kid. The upshot of it is that the court awarded 239 hours of compensatory education. And obviously there would be an attorney's fees award as well. So that's worth noting as just the importance of making sure your story gets across. Finally, on to free appropriate public ed. Couple of things about this. The first case is one, again, where the school district prevails. Maybe not all that remarkable. The kid has dyslexia and a lot of problems with oral reading fluency as a result. The courts seem to be impressed that when the kid was in the district for a relatively short period of time, the kid did make some fairly significant gains in reading. Not enough for the parent who pulled the kid out and put the kid in a landmark school. The court said, yeah, the kid did make more rapid progress in landmark, but then said, yes, but the goal of IDEA includes least restrictive environments. So progress that the kid made in a non or less integrated environment is not all that demonstrative of anything. What's more, we look to the evidence as of the time of the IEP. There are a couple of, I think, flaws with this. One of which is that the parent, typically who pulls a kid, I'm not sure this Court of Appeals figured this out, typically doesn't have a choice of an integrated environment for the kid. You know, the specialized schools are specialized schools. And so kind of tagging the parent with responsibility for that, at least from my opinion, doesn't seem to make huge amounts of sense. The other thing is it's always been, this idea that, well, at least I've heard it said, that there's something of a snapshot rule with respect to the IEP. You look at the time the IEP is made. The thing is, though, that evidence of what happens afterwards may be relevant to what the kids' needs were, or even what the school district should have been aware of at the time that the IEP was made. And in fact, if you look at the Andrew F. case, the 2017 case that's the last and perhaps final word of the Supreme Court with respect to free appropriate public ed, they emphasized the rapid gains the kid made after the parents had rejected the IEP and put the kid in the private placement. So I think that there is some room for argumentation to be made that might work at a bit of a cross purpose to what the Court of Appeals was saying in this case. I did want to mention that Crofts case again, but I won't say anything more about it at this point. The Falmouth case I did want to mention, partly because it's, again, one where the parents win, although again, it's at the district court level rather than the Court of Appeals level. But it's also one where you've got kind of the same pattern that we had seen a little bit before, where a kid has a diagnosis other than dyslexia, was a diagnosis of ADHD, did get some services. It only becomes gradually known over time that the kid does have dyslexia, but the SPIRE program was apparently not going to be adequate to meet the kid's needs. The school district did eventually adopt the Linda Mood Bell program, which again is this kind of elaborate multi-sensorial kind of approach to reading. But as with the Orton Gillingham in the other case, they didn't seem to implement it with any real fidelity and then discontinued it rather rapidly, perhaps again because they didn't have the familiarity with the program. And the court was quite concerned that the district was really just going for standard operating procedure rather than looking to the individual needs of the kids. Again, something that might be important with regard to how one wants to present a case to a hearing officer or other decision maker. And then finally, I just wanted to mention with regard to free appropriate public ed, yet another return to school roadmap. I don't think that this one is all that earth-shattering, but it does summarize rather neatly a lot of OSEP's positions with respect to what it is you need to do for IEPs. So it's a probably good summary, again, if you just want to bone up on that particular issue. What's next? Well, let me mention a word about infant and toddler programs. Yet again, we have an OSEP/OSERS type letter here. Folks may be familiar with these acronyms, may not. OSEP is the Office of Special Education Programs. OSERS is the Office of Special Education and Rehabilitation Services. OSERS is kind of the parent organization of OSEP, but you don't really need to know that. They're all federal regulators whose job is to implement IDEA, among other things. The big thing about this one is that the OSERS people finally got around to emphasizing that even if you've got problems with COVID-19 and with trying to get the school district personnel and the related services personnel and everybody else where they ought to be, you've still got to, if you're the school district, comply with the obligation to provide appropriate services in accordance with, here they're talking about early intervention, so a family services plan, or for that matter, for an IEP, and you have to be prepared to make the transition for the kid to IDEA type services at age 3 or whatever it is the kid becomes eligible under the state law. So it does keep emphasizing that kind of what I think of as a no fault aspect to the obligation to make sure you provide appropriate services. And I think that's worth, devoting a little bit of extra attention to. We've been kind of hinting around a little bit at the least restrictive environment topic. And I did want to emphasize the LRE development in HW against Comal. This may, for better or worse, be the most important case of the last 12 months having to do with IDEA. Why do I say that? Well, in some ways, it may not really be that surprising. It's a little surprising. The kid has Down syndrome, and as we, I hope, all know, a lot of kids with Down syndrome conditions are quite successfully integrated into mainstream general education, often with accommodations and with modified curriculums and everything else. Even as they get older, there seems to be a quite realistic way of accommodating kids who have those conditions. Here, the school district did integrate at the beginning, then ultimately offered what the court said was a blended program. But if you read just the description, it becomes pretty clear that it was a self-contained program. There was integration for part of the day, but it looked to be the non-academic parts of the day, and the services would really be in the self-contained program with respect to anything vaguely academic. The court said that that's okay. After all, the kid did make progress with respect to the kid's IEP goals, and it wasn't clear how much progress the kid had made in general ed. There were obviously some efforts to accommodate the kid in general ed before the school district pushed for this more self-contained program. The big thing that appeared to be the factual issue that the court went off on was that the kid was a behavior problem. Hit, bit, and kicked staff and peers, yelled, screamed, moaned, and grunted in the classroom, took materials off desks. And that seemed to be of some real concern. Now, the court did not say what, if anything, at least in any detail, what, if anything, had been done to try to modify the kid's behavior or accommodate the kid's behavior, which I think any advocate would want to pay attention to. But the other thing that is of importance here, and I think maybe a little bit revealing with respect to attitudes, folks who've been following special ed law, remember that there's a case called LH against Hamilton County out of the Sixth Circuit from 2018. That was the big case of 2018, really, this LH case. What the court there said, and it seems to me to fit with what the majority of courts have said, although some may disagree with me on this, is that the big issue is not whether the kid makes progress in the general curriculum while in general ed. It's whether the kid makes progress on the kid's IEP goals in general ed and otherwise is able to get some benefit out of the general education placement. The court here says specifically, we disagree with LH, and no, what matters is making progress in the general ed curriculum rather than in the kid's own IEP goals. That, I think, is a huge attitudinal difference between this court and a lot of others, and it seemed almost as though the writer of the opinion was trying to set up a conflict in the circuits that would go up to the Supreme Court. Whether there will be any legs, any following of this opinion, I don't know, but I do think it probably deserves some attention and some following. Where are we next? Well, I often think of least restrictive environment and related services as really being the same issue. Not always, plainly, but there are a whole lot of placements in general education or in more integrated settings that will work just fine if the services and accommodations are there, and will be utter disasters for the kid and often for the kid's peers if the school district goes at it half-heartedly, or if the related services and accommodations are not where they ought to be. That, however, is not the big issue in the one local case. I'm really trying to include pretty much everything local in the outline here. So this is Judge Dow at the Northern District. it's kind of a convoluted case, so I don't know how important it will be ultimately. But the big deal is that this kid has a seizure disorder and needs emergency administration of a rectal medication or medication delivered rectally when that happens. IEP provided for a nurse to be on the bus and at the kids' school district created private placement, and that would go forward. At some point, there was an aide, a medication aide rather than a nurse. Then again, the IEP provided for the nurse rather than the aide, but the kid, because of COVID, was attending school remotely, so that never actually got implemented. Finally, the parents want to get it implemented and sue for a preliminary injunction because, according to them, the Chicago Board of Ed is dragging its feet in doing that, saying that, well, there's a nursing shortage, we can't get any personnel who are able to do this. The IEP, after all, calls for a nurse. Judge Dow did not grant the preliminary injunction, saying, well, we're not really maintaining the status quo here because the kid's been out of school because of COVID, and kind of just leaves it at that. Obviously, there needs to be another chapter written here, and it could be that there was some form of settlement or result that met the kid's needs, but it's maybe at least a matter of some concern that whatever it is, preserving the status quo seemed to be the key thing that the court was emphasizing rather than anything else with regard to the preliminary relief. Well, that makes a bit of a segue into placements and where it is you put a kid and all that. And I was a little unsure just how to caption this set of cases. They're all local, and they all deal with placement, and they all, as a matter of fact, deal with residential placement. But as important, perhaps more important, what they actually deal with is non-approved placements. What does that mean? Well, folks may know that a lot of kids, even in this day and age, are tuitioned out of the public schools by the public schools into private schools. And those private schools may or may not be residential for kids who've got often very, very severe impairments, sometimes significant behavioral challenges and the like. Residential placements may be permitted, may be justified. The difficulty is that the state maintains a list of approved placements based in part on the conditions of the placement, but based also on economic factors, whether they think that the reimbursement rate is adequate or whether they think that it's excessive or other such things. Now, both the state and the school district under IDEA have an obligation to maintain a spectrum or a continuum of placements that include, when necessary, things like residential placements. But you can imagine the economics are such that states are often quite, well, I don't know what the right word is, quite limited in which places they approve and which they don't. A case called Carter, way back when, 20 or more years ago, out of the Supreme Court, said that reimbursement, tuition reimbursement, could be provided even though the unilateral placement that the parent chose was not approved by the state. After all, the parents have no way of controlling who the state approves and who they don't. And what's more, the whole idea is that the parents aren't going to be bound by the same placement obligations that, say, a school district would be. So what happens here? In trust, the court grants a preliminary injunction requiring the defendant to pay for the residential placement of a student at a place called Brem Preparatory Academy. The parents in the school district had worked out that placement as part of a mediation agreement, with both the parents and the school district being under the impression that it was in fact an improved placement. It was one that the school could place a kid in, and the state would pay their share of that under the the applicable Illinois regulations. Turned out, surprise on everybody, it wasn't approved. The court says, well, yeah, but everybody concedes that it's free, appropriate public education for the kid. It doesn't appear that there's anything else there. And what's more, the state regulation says that unapproved placements shall not be used, but it doesn't say that the placement is ineligible for tuition reimbursement, nor that there's anything else particular that forbids placement in an unapproved place. Here, the parent had gone ahead and worked out the paperwork for the placement, and the court says, so pay for it to the school district, and kind of leaves to the school district what it is they want to do against the state to try to get reimbursement. I thought that I would dig into the due process hearing procedure cases as well here in order to see if there are other cases that look along the same lines. And sure enough, there are. Folks may know, if you've ever tried to dig into the due process hearing decisions that are posted on the web by ISB, by the State Board of Education, that they're really, really, really slow at posting decisions to the point where it gets a little frustrating to try to keep current that way. But a couple of cases, among the more recently posted ones, are both ones where the parents in the school district worked out that the only place that could accommodate the kid was one that was not on the approved list. In the I guess it's 0038 case, the school district and the parents contacted over 100 programs and only found this one that would take the kid. It was out in Utah, and it was expensive for sure. $200,000 and more. Parents made a deposit, but obviously couldn't pay the entirety of the thing. The hearing officer, an Illinois hearing officer, ordered the school district to pay, but at the same time said that she, the hearing officer, lacked the jurisdiction to force the State Board of Ed to reimburse the school district. And there's actually somewhat conflicting law on that in various places. A lot of courts have said school districts themselves don't actually have a cause of action against the state educational agency. Others have approved the ability of bringing in the state as a co-defendant, at least in court. But in any case, the hearing officer said that no power vested in her. The other case, the 0044 case, is kind of similar. This is a sad case, a kid who had apparently some sort of sexual misconduct misorder, unless I'm mixing that up with the other one. But in any instance, no, actually the first one was the one with the sexual behavior problem. And the other one was, again, just a kid with a lot of very severe disabilities, including aggression and elopement. Again, there was only one placement. It happened to be in New York. Here they contacted 60 programs, but the place cost $500,000 a year. Now, you know, the rule is that the cost itself is not a disqualifier under IDEA, and states are, of course, encouraged to spread the cost by picking up the excess costs of placements, as long as they do that without providing an incentive to place the kid residentially where that's not appropriate. But here again, of course, the state balked as well and did not approve the placement. Hearing officers orders the school district to pay. Whether the school district then will go out and sue the state educational agency ISB under a state law cause of action, I am not sure. It could be that they'll be able to come up with an IDEA cause of action or be able to negotiate it out. But it's worth noting that the parents do prevail really in all of these cases, irrespective of whatever the state is doing. Wanted to mention just a little bit about maintenance of placement topics. Some of these can probably be disposed of in a sentence, although whether I can keep myself to that, I'm not absolutely sure. First one, Doe against Portland. Bottom line for this one, is that the hearing officer had ordered reimbursement for private services that the parents got from a period actually from the end of 2017 all the way up into 2020. But the hearing officer at the same time had said that the IEP offered by the school district at the beginning of 2020 did offer free appropriate public education. The parent tried to argue that the reimbursement order constituted an agreement with the state in the form of the hearing officer that the private placement was the appropriate placement for the kid. Court of Appeals says, nice try, but in fact, all that the hearing officer did was say that that was true up until 2020. Going forward from 2020, the hearing officer said that the IEP offered by the school district was what was the appropriate education. And so there was no agreement of the kind the parents wanted to rely on. On the other hand, in this SC case out of the Ninth Circuit, this is again a real kind of challenging case. The kid has a thing called Prader-Willi syndrome, which involves overeating, connected usually with a bunch of other disabilities. Has to be in a totally food safe environment, which is pretty much impossible to do at a public school, although I guess with enough effort it could be done. Ultimately, the parents do prevail and get the placement that they want. The administrative law judge affirms that and says, place the kid. School district balks and just doesn't do anything. And the court here approves a preliminary injunction saying, yeah, you got to do it, which is worth noting, once again, reinforcing this idea that the decision by the administrative law judge creates a new status quo if it goes for the parents. The YB against Howell case, I thought I would put in short story on this one. Kid transfers had a private placement at the, I think it was actually an out-of-state placement where the kid had been, but don't hold me to that. But in any instance, the new school district doesn't want to maintain it. Court of Appeals says that maintaining the private placement is not an obligation once the kid has transferred to a new school district. Rather, the obligation under IDEA is simply to provide comparable services to what the previous school district had provided, and a new IEP can be issued at that point. The EE against Norris case, I did want to mention, because the thing about this one is that the ALJ did order a different placement for the kid, but it wasn't the one that the kid had been in at the beginning of the dispute, nor the one that the parent continued to want. The court says the last undisputed IEP placement is the one that has to be maintained under Section 1415J, the maintenance of placement provision, rather than what the ALJ provides if the parent doesn't want what the ALJ provides. Now, it doesn't actually contradict the Doe against Portland school, because there the parents were trying to rely on simply the reimbursement order rather than anything else, not trying to maintain what at that point was the status quo. Here they were, and the court does in fact decide in favor of the parents. What next? This does have a certain feeling of one thing after another, and I regret that, but that's kind of the nature of these things. I'm hoping that folks are caffeinating appropriately and keeping following. So mootness, what about mootness? Well, if, as in Johnson, the parents move out of the school district, and if, as in Johnson, they fail to keep pushing for any kind of remedial remedy like compensatory education, the court is going to find the case moot, and sure enough, the Fourth Circuit did. You need to know anything else about mootness? Well, you know, I mentioned I teach Fed courts. If you haven't taken the course recently, maybe, just maybe, you ought to be aware that back in 2016, Justice Ginsburg, bless her heart, actually did put on her federal courts teacher mantle and said in a case, probably nothing to do with education, a case called Campbell-Ewald, E-W-A-L-D, against Gomez, that an unaccepted offer for the full amount for which a plaintiff would be entitled that's offered in settlement of the case does not moot the case. In fact, an unaccepted offer of settlement is a legal nullity. It's just an unaccepted offer of a contract, and it does not have that role. That actually contradicts a bunch of old special ed cases. So if you're not aware of that, you should probably be aware of it. Other things, since I've been teaching Fed courts and I can't resist, folks may or may not be aware of a case that came out back in 2020 called, of all things, Lucky Brand Dungarees against Marcel Fashion Group. It doesn't have anything to do with mootness, but it does have to do with everybody's favorite topic, with res judicata. And this time, Justice Sotomayor says quite correctly, and keep this in mind because it could be important in a case, that events that occur after the final judgment in an earlier litigation are highly unlikely to provide the basis for a defense of res judicata by the party or by the parties in the earlier case. So stuff that happens after a decision in a case, conceivably could be the basis of collateral estoppel or issue preclusion, but it's not a basis for claims preclusion. And if that doesn't make any sense, you can, kind of forget about it, but it may be of significance in a case that you handle. You should probably also, as long as we're on the topic, there's this oddball case, oddball simply in the sense of how the names are spelled. Uzue Bunam, U-Z-U-E-B-U-N-A-M, from last year, that said that a nominal damages claim of $1 keeps a case from becoming moot. So that again may be of significance, hard to tell. Whew. Got through all that? Good. You're still awake? Good. What about due process hearings? Due process hearings, the first one, I just thought I would throw it in. It seems somewhat relevant. It's Third Circuit. Parent essentially rejects 3 days after making it an agreement that the parent had reached with the school district and that was approved by the ALJ, and that the administrative law judge said was a full and fair settlement based on the record, and put all stuff into the record based on that. When the parents sue then to try to undo the placement, the school district comes back and says, no, you don't have any jurisdiction for that. At the minimum, it's just a declaratory judgment claim over a contract. Court says, well, yeah, maybe, but the fact is that involves an issue of federal law. And what's more, it's a dispute by the parent of what the administrative law judge did in approving the placement. So that's a challenge to an administrative law judge decision. And under section 1415, that's where the jurisdiction lies. The parents may ultimately lose, but there is jurisdiction. Does that really matter in a case you're likely to encounter? I don't know. But it's worth pointing out that jurisdiction is a broader concept maybe than some parties or courts might think. Letter to Zirkel. So there's this kind of gadfly character out in Pennsylvania named Perry Zirkel, who spends a lot of time writing letters to the Office of Special Education Programs to try to get guidance on various topics. He writes one that asks, does a parent's failure to provide proposed resolution of the problem in their due process complaint, as required by the regs, restrict the authority of the hearing officer to order prospective relief, such as a team meeting, or retrospective relief, such as compensatory services or reimbursement. Response. Basically, what they say is that this sufficiency challenge, and if folks aren't familiar with it, you kind of have to look back at the statute and the regs. The statute to the sufficiency of the due process hearing complaint has to be made initially within 15 days of receiving it. If you don't do that, the complaint is deemed sufficient. What's more, there's no need to specify in the complaint things that you don't know yet. So you can only propose a resolution to the complaint to the extent known and available to the party, and that's all that is required. So the upshot seems to be, no, it doesn't restrict the hearing officer unless the complaint is deemed insufficient, in which case the parents have to replete it anyhow. There's another question, and I won't go into that. The third question, though, is really the big one here. So question 3, and I'm going to quote this again. You state in your correspondence that some states, especially those that opt to use state administrative law judges, engage in practices that dismiss a due process complaint and or issue summary judgment on the matter without holding a hearing. You ask whether such practices, other than when a hearing officer finds the complaint insufficient, violate the party's right to a hearing under IDEA and or arguably 14th Amendment due process and procedural rights. The OSEP people say, well, we're limiting this to the hearing rights afforded under the IDEA. And then they say, among the rights IDEA affords parties in any hearing conducted under the hearing regs is the right to present evidence, confront, cross-examine, and compel the appearance of witnesses. The only provision in IDEA or its regulations that contemplates summary dismissal is when the due process complaint is insufficient. To the extent any summary proceeding in a hearing on a due process complaint, other than sufficiency determinations, limits, conflicts with either party's rights, including the right to present evidence and confront, cross-examine, and compel the attendance of witnesses, we believe such proceedings can be used only when both parties consent to use the summary process, e.g. cross motions for summary judgment. So the parents can insist on a hearing, it appears. And that's big news. I don't think anybody had seen an interpretation that goes along those lines, or even seen a court do something like that. So do keep that in mind if you've got a situation where you want a hearing and the other side wants a summary adjudication. What's next? Well, I did want to make sure I said a word or two about administrative exhaustion. Administrative exhaustion cases are kind of a dime a dozen, and that's true here as it is in a lot of others. A word really just about each of these, and really only about a word. In DD, the kid had a lot of behavior difficulties, got removed from class. The school district wanted the parent to come in essentially to serve as an aide. The parent files suit and says that they're entitled to damages and other remedies. They work out at the due process hearing level, actually at mediation on the due process hearing, all of their IDEA claims, but the settlement says that all ADEA damages claims are hereby preserved by this settlement. The court says, no, you, the parent, cannot bring an ADA suit now because mediation and reaching a settlement does not exhaust the administrative process. But, says the parent, a reserved issue in the Fry case was whether simply demanding damages was, under the text of the statute, enough to excuse exhaustion. And the court says, no. Interestingly, there's a dissent by a kind of textualist Court of Appeals judge saying, yeah, but you know, that's what the statute says. And I think that's what the parents were going for here, or perhaps the parents' lawyer, that they're looking for a textualist approach, which in a whole lot of situations would call for excusing exhaustion or not applying exhaustion, where even under arguably Fry, it might be required. Valentin Marrero is probably not quite that dramatic. The weird thing about this one is that the parties litigated in the district court kind of forever, for like 4 years or something. But the school district kept on insisting through the whole thing that the parents hadn't validly exhausted, and they finally take up the final result on appeal on the ground that that there wasn't exhaustion. And sure enough, the court rules in their favor and knocks out the parents' claim. The student A case, I thought I would put, whoops, that was an error, put in, this is a case that looks a lot like the litigation in DC and the Jamie S. case in the Seventh Circuit about failure to identify and process, basically identify, evaluate, and place kids who are coming into the school system. And from what the plaintiffs claim anyway, San Francisco apparently is not doing a good job of that. They bring a class action. The court says, yeah, but in the absence of identifying a specific kind of practice or procedure or policy, there's no ground for excusing exhaustion under a futility theory. That's kind of the part of what the reasoning was in Jamie S., but that the court didn't really develop. On the other hand, the court here doesn't really develop the Walmart type reasoning for class actions that the Jamie S. court went into. What does it mean? Jamie S. is going to be out there in the Seventh Circuit anyway, so it may not be all that important, but it does mean that if you do want to bring a class action case, emphasize policies. Seems to be the key thing. President Sturgis, I thought I would mention, this one is at least a cert petition has been filed. In many ways, it's kind of comparable to DD. There was a settlement. The settlement had provided for everything except damages. The case really does look like a Title II ADA auxiliary aids case. The one was where there wasn't a qualified sign language interpreter. The kid was left behind in academic progress as a result. It looks actually a little bit like the Tustin litigation from 2013 in the Ninth Circuit, but it seemed that the court there didn't consider in any serious way the objection that the school district advanced here on exhaustion. And the result is that the school district prevails. But again, we have a dissenting opinion saying, no, this is completely wrong. What in fact the law provides is that if all that you've got left is the damages claim, then you don't have to somehow keep the case alive, even though a settlement is being offered with regard to the IDEA claim. I wanted to put in one place these couple of cases we'd already talked about that talk about compensatory ed. You know, for example, the idea that you have to show that there's actually a loss to the kid, or at least according to these courts, a loss to the kid in the JN case or in Johnson, that you have to show, or you have to keep demanding the comp ed in order to keep the case from becoming moot, where that's all that you've got left. Settlement, what about settlement? I just thought I would throw in the DW case. The SW case has been the topic, of discussion for a long period of time among special ed advocates. And you'll be pleased to know, if you didn't know already, the case finally settled $250,000 for the parents and attorney's fees of $75,000. Eventually, parents do sometimes win cases, and they do it either by settlement or by prevailing in the case. Where are we then finally? Well, we're at section 504, and you know, there are Section 504 cases out of the Court of Appeals that have maybe more of an overlap. Obviously, those exhaustion cases all did. But the couple of cases that I thought really were significant were ones that were non-special ed. The first one is Payan. This is, I think, a highly significant case. Again, if I were kind of looking for cases of the year, it would be right up there, even though it's not technically a special ed case. So the case involves the Los Angeles Community College District. The plaintiffs are plaintiffs with various visual impairments or blindness. And they say that, you know, the community college has made some efforts here, but they're just not good enough. We can't get access to in-class materials that are accessible to us. Textbooks are not available that we can use. The education technology is swell, but not for somebody who can't see. The websites are not consistently made accessible. And what's worse, when we're going off to do research on the databases in the library, that material isn't fully accessible to us. The students actually lose in a jury verdict at the district court level. But, says the Court of Appeals, the students were correct in saying that the jury should have been instructed on a disparate impact theory, and that you don't have to, in order to prevail under Section 504 or the ADA, you don't have to show an out to get them, or for lack of a better word, intentional discrimination kind of a claim or kind of a showing. Disparate impact is enough. Now you might say, yeah, but we knew that ever since the 1980s in interpreting Section 504, the Supreme Court had, we thought, said that disparate impact was valid, at least for some Section 504 type claims, not for all of them, not for a claim challenging welfare type allocations under the Medicaid program, but for other things like education, for sure, yes. But that has been challenged right and left since that time, mostly under the theory that only intentional claims are permitted for private causes of action under Title VI of the Civil Rights Act, and Section 504 and Title II of the ADA incorporate remedies under Title VI. It's been explained many a time by, among others, me, that, yeah, but the reason for that is that Section 504 is different, or the reason for the holdings with regard to Title VI is that Title VI is different, and that only intentional conduct is barred by Title VI, whereas the court, way back when, said that Section 504 was intended by Congress to reach disparate impacts. But the various defendants of the world have not let that rest. And quite recently in the CVS against Doe case, they were arguing to the Supreme Court that disparate impact claims are no good under Section 504 and by the extension under the Affordable Care Act. The CVS folks, however, after the briefs had already been filed, gave up on their litigation, apparently feeling some pressure from people who shop at CVS that maybe it wouldn't be a good idea to pursue this in the Supreme Court. Maybe not, I don't know what their motivation was. But in any case, Payan establishes that Section 504 does, in fact, provide a private remedy for folks who are claiming disparate impact discrimination. And I think that that's a big deal to see a Court of Appeals emphasize that. I guess in addition to the CVS against Doe case now, we may be working towards something that looks like a consensus by the Court of Appeals. So this is kind of like a good news, bad news, perhaps from an advocate's point of view. The last thing we wanted to make sure that we talked about is the Cummings case. Now, folks, I know some folks who are are on the session here have been working on this. I'm not going to be sharing any work product or anything that anybody has been working on that I am aware of. But what you should know is that the Supreme Court just recently, back in April, decided that the Section 504 incorporation under the Affordable Care Act does not extend to a claim for damages or emotional distress. So in other words, Section 504, although it may provide injunctive remedies, may provide some forms of compensatory relief, you think perhaps out-of-pocket expenses or the like, does not embrace pain and suffering or emotional distress, which is what? And the case is actually a fairly simple one. A person who was deaf and actually had a quite significant visual impairment was not offered a sign language interpreter by this actually quite wealthy rehabilitation services provider, I believe in Texas. And she eventually does get services elsewhere, but sues for the distress of being turned down and all the effort at trying to get the services. And it goes all the way up to the Supreme Court, and the Supreme Court says, no, you're not entitled to that, under a kind of a theory based on the Pennhurst case that folks may remember, the idea that if it's a federal funding related statute, you're entitled only to ordinary remedies that would be provided in a contract type claim, because after all, the federal funding agreement is essentially a contractual arrangement between the federal government and the state or whoever else is receiving the federal money, that then puts them under the obligation not to discriminate on the basis of disability here under Section 504. Of course, there is a rather extraordinary breadth of implications to the case. Obviously, Title II of the ADA adopts Section 504 remedies, so there could be issues with regard to Title II here that appear to be inescapable. What's more, obviously, as we mentioned, the Section 504 remedy incorporates that of Title VI, and Title IX also incorporates that of Title VI. It could be that courts will take this interpretation and apply it to Title VI and Title IX as well, which again looks to be, put it mildly, distressing, I guess, for lack of a better word. It makes you kind of wonder, I mean, just if you think of the Title IX case law out of the Supreme Court, you know, Franklin against Gwinnett, where the teacher molested the kid sexually, or the Davis against Monroe County case, where the peers engaged in this terrible campaign of one kid in particular, terrible campaign of sex harassment against the kid. What were they thinking? I mean, obviously the damages there are primarily emotional distress, and the court nevertheless said there's a valid cause of action here. So it could be that we'll find that perhaps this will not be extended any farther than Section 504, but I don't know whether we can count on that. And what's more, even with regard to Section 504, obviously the implications are quite dramatic and in my view, quite harmful. Now, are there possible end runs or ways around or anything like that? I'm not absolutely sure. I kept thinking that, well, maybe I should try to, folks may know I teach torts as well as a number of other subjects. Maybe I should be trying to apply my tort law here. And are there instances where people have used contract claims for stuff like personal injuries? And sure enough, of course, that's the whole history of product liability. They started out as warranty claims and eventually became something that we think of as tort product liability claims, maybe physical injuries, since they've been permitted under warranty type things could be the basis for a valid damages claim, irrespective of what the court did in Cummings. Obviously, there's the possibility of trying to join tort claims or join other claims for which the state courts have found emotional distress damages to be appropriate as, say, pendant claims for a Section 504 cause of action, or perhaps as standalone claims, either in state court, or if you can find a basis for it jurisdictionally in federal court. It may, in fact, be that you want to stay out of federal court. So that's worth keeping in mind. I did actually, ages ago, put together a bit of a law review article for anybody who ever wants to dig it up at 2012 Utah Law Review 429 on common law causes of action for disability discrimination. So things like contract and tort and the like, some of which may provide for emotional distress damages where 504 isn't fitting into the bill. It did occur to me that there may be a Section 1983 claim for violations of Section 504. After all, the Supreme Court said a few years ago in a case called Fitzgerald against Barnstable School Committee that a private right of action statute where the private right of action is simply implied is unlikely to preempt a constitutional claim under Section 1983. Perhaps that can be extended. Obviously, there are things under equal protection and due process that people haven't developed because Section 504 is there. There may be valid claims under the Illinois Human Rights Act or other state law provisions that people can come up with. But I do think that there are some quite serious issues here presented by Cummings. Maybe there'll be a federal legislative fix, but I guess I have to say I'm not holding my breath for that. So on that, not in my view, terribly cheery note, maybe I should stop talking and turn things over to Barry, and Barry can deal with questions and concerns and the like.
Great, thanks, Mark. Really appreciate the detailed analysis. Some terrific information, cases that I'd heard of and heard more from you, and then others that weren't on my radar screen. So thank you very much. I have a couple of questions. Just a reminder for folks, if you do want to ask a question, you can type it in the Q&A box, or you can click on the raise your hand feature and I'll unmute you and you can ask your question directly. So the first question, just to follow up on Cummings, it says, when you talk about Cummings, can you compare the constitutional underpinnings of Section 504 to the constitutional underpinnings of the ADA?
I missed the last word there.
The constitutional underpinnings of the ADA. So saying that, you know, since they're not necessarily, you know, have the same constitutional spending clause versus the Commerce Clause, would that make a difference? Is what I assume the question is getting at.
No, it's I think a real valid concern, and you can certainly argue that given the equal protection whole idea behind Section 504, or for that matter, behind the ADA, frankly, as well as the idea of just in general trying to promote integration on a plane of equality, as is kind of my mantra, that the idea that reducing everything here to simply a contract relationship between the states and the federal government that would apply as easily for, I don't know, the states buying something from the federal government or the federal government buying something from the states seems just to miss the boat. The difficulty is I'm not sure that that has ever quite penetrated the Supreme Court. So the Supreme Court made a huge deal in Cummings about Barnes v. Gorman and the fact that in knocking out punitive damages, the court had just followed this contract analogy straight all the way through. Even if you accept the contract analogy idea, of course, as Breyer pointed out quite correctly in dissent, there are tons of contract claims where you can get emotional distress. You know, a lawyer malpractice claim involving something where distress could be a predictable result, like an adoption case. Plenty of courts have approved that. But again, that didn't seem to matter to the court. They said, well, what's in general the remedy? So that may mean that the court is just not very receptive to that idea. But I think the underlying tenor of the question is quite well informed in suggesting that maybe there is this whole range of equal protection or due process claims that people want to bring, irrespective of whether there's a Section 504 claim out there or not. There's a guy named Mike Waterstone who put together a law review article a while back on underdeveloped equal protection and due process claims. I can't remember where it is or even exactly when it was, but it might bear a little bit of research.
Great, thanks. And speaking of law review articles, we have a request if you could just repeat the citation for the law review article on the common law causes of action.
Oh, sure. It's 2012 Utah Law Review 429, and the title is simply The Common Law of Disability Discrimination. And I checked, and the Utah Law Review website only goes back to 2014, so you can't really get it there. However, and folks should probably know this if you don't know it already, there is this entity called SSRN. I think it's at ssrn.com, which if you're willing to, I don't know, give up your privacy and register for them, will allow you to download all sorts of law review articles and things for free. So if you go to that SSRN website and you type in under advanced search the title, The Common Law of Disability Discrimination, or Utah Law Review or something like that, or just my name, you should be able to come up with the article. Or if that fails, email me and I can send you a copy.
Great, thanks, Mark. This is less a sort of a specific question about the law, but more about sort of your opinion, given sort of the large number of cases where the school districts won. This question says, a couple years ago, it seemed like a lot of wins for parents. Now the tide has shifted to school districts. What do you think this is attributed to? Just increasing polarization of politics?
Yeah, that again is a real challenging question. There are people, including that guy, Perry Zerkel, who do these elaborate studies of winning and losing and who prevails in which cases. The difficulty I always thought with that is that the cases that wind up being litigated are not a random sample. The cases that are strong settle out. And so you never see them actually show up in the reports. Even in a lot of cases where the parents fail at, say, the district court level, wind up settling in a way that's quite favorable for parents on appeal. So I'm really cautious in trying to pick out a trend there. I guess I'm more concerned about if you've got various interpretations of the law that might make it difficult for kids or parents to prevail, and kind of keeping an eye out for those and recognizing that there may be obstacles either to be surmounted or to be run around that are presented there, rather than trying to do the empirical stuff. But hands up for Perry. I mean, he's really very good at trying to monitor how many cases win and how many cases lose.
Great, yeah, it's a tricky one to answer for sure. We don't have any other questions so far beyond those that I've raised already. Again, if people want to ask a question, we've still got a little bit of time left. You can type it in the Q&A box or click on the raise your hand feature. Just a couple things while we're seeing if we have any other questions. Just a reminder that if you do want CLE credit, you just need to shoot an email to me at barryt@equipforequality.org. I've also put that address in the chat so you can cut and paste. Just send me an email when the session's over, as well as your ARDC membership number, and we will take that from there. Also, just wanted to let folks know that our next Disability Rights Consortium meeting will be on July 27th, also Wednesday from 9:30 to 11, so the day after the ADA anniversary. And our featured speaker will be Commissioner Rachel Arfa from the Mayor's Office for People with Disabilities. So if you have any, she'll be sharing sort of the initiatives that her office is undertaking and updates on any work that they've been doing. And then also if people have any suggestions or comments about disability related services within the city of Chicago, certainly there'll be an opportunity to pose those issues and questions as well. So we'll be sending out an email on that, but I just wanted to let folks know that's the next session that we'll be having. And I'm looking, I'm not seeing any other questions. Mark, was there anything that you didn't get to? Or that
Yeah,
you
I was just
We have a
thinking,
couple minutes.
obviously we've got a lot of expertise in the group here. And maybe I don't know whether this would be appropriate from your perspective, Barry, but I do think it's important for folks to keep talking about Cummings in particular, in ways in which claims might still be able to be pursued, irrespective of what the Cummings court did. And I know that I'm trying to work on that issue, at least to some extent. And if folks do want to be in touch with me, they should certainly feel free to do that. I think Equip for Equality, I think, has some interest in this topic, needless to say, as well. And Barry, I don't know if you wanted to say anything about that or what the organization might be interested in or working on or anything like that.
Yeah, I think some different advocates have been, started to, do the discussion. So folks can just, if you're interested in being part of that discussion, feel free to shoot an email to me, and we can sort of bring you into some of the discussion that we've been having. I mean, I think some of the things that you mentioned, like, what options there might be under the Illinois Human Rights Act and alternatives there. Obviously, there's some barriers that there are on that end of things too. So, no perfect solutions, but I think this is kind of a time where brainstorming is really helpful as we try to figure out the implications of this decision and how we can try to, from an advocate standpoint, minimize the impact it might have on the rights of people with disabilities, both under 504 and other laws.
Yeah, and I do want to make sure that folks are aware of the Human Rights Act. I mean, there are not only are there cases, at least at the appellate level, that do say that emotional distress damages are permissible under the Illinois Human Rights Act. There is at least some necessity to exhaust, it appears, although I don't know and have not dug into excusing exhaustion or other such things, but there is also a provision that kind of like with Title VII does allow an opt-out, at least with respect to some forms of claims under the Human Rights Act that may prevent exhaustion from being a serious obstacle, at least if the claimant has initiated the process with respect to the Human Rights Act claim. There are some rather challenging difficulties, it appears, with choice of forum under the Human Rights Act as to which administrative agency, for example, would be able to provide what form of remedy. And I think that probably we're all going to have to be doing a lot of research on that if we want to pursue the IHRA as an option. I frankly, am quite, I guess because I've written on it perhaps, interested in the idea just of plain old common law type claims. There is obviously intentional infliction that is out there, but there have been other cases, and folks who do employment discrimination law know this as well, where even if you're relying on a federal claim for at least some of the relief, what you want to do is make sure that you assert the pendant state law claim, in part because, under, say, ADA Title I or a sex discrimination claim under Title VII, there are damages caps. And there aren't damages caps under intentional infliction, for example, or assault or battery, or even for that matter, some contract claims for which there might be an emotional distress component that would be permissible. So I want to keep encouraging folks to not only think the state statutory law, but also to the extent you can brainstorm anything having to do with state common law or judge-developed law, because that might be what ultimately plaintiffs are going to be relying on in cases of this type.
Yeah, that's a really great point. Sort of like, throwing the kitchen sink. Think of anything you can do, right, to try to get around some of these challenging decisions. And I think the common law suggestion that you made is great. And obviously you've written on that. So applying some of your previous thinking to this situation sounds like a really great opportunity. Not seeing any other questions.
No, okay. Well,
So,
thanks to everybody for all your attention. I know it's been kind of a long monologue, but I've appreciated having you out there, and hope that this meets some of your needs, and hope you have a good summer and everything else.
We absolutely appreciate everything you provided today. Really helpful information, and look forward to hopefully having you back next year to update us. Hopefully, maybe we'll have some good news to share on some of these issues we talked about.
Yeah, I certainly hope so. Okay.
Right. Thanks everybody
Right,
for your
well, thanks
attendance
again.
today. Take care. Bye-bye.
Okay, bye-bye.